Welcome viewers to this video. What we are discussing in this video is issues pertaining to the Employment Act. So this is part 1 of the Employment Act. What we are looking at is to look at about the Employment Act. What is it about? So we want to appreciate that the Employment Act mainly is, as the name implies, is to do with the employment. This is a law that guides the relationship between the employer and the employee. So most of the issues which are covered in the terms conditions of service, the contracts, what are contained in the Employment Act. So it provides the minimum conditions that can form as a basis for the agreement that can be there between the employer and the employee. So the moment you've engaged an employee, you should be looking at to say, am I in compliance with the Employment Act, for example? So you talk about issues pertaining to wages, annual leave and all that. So in this particular session, what we want to look at is to say, as part 1 of the Employment Act, what we are doing now is to look at a summary, what the Employment Act is all about. So the Employment Act came into effect in the year 2000. Before 2000, we didn't have the Employment Act. So it came into effect I think in the past years there was like government circulars and all that, which were guiding the employment relationship and all that. So it came into effect in the year 2000. After that, I think there was an amendment that happened in 2011 after the introduction of the Pension Act. And also we had another amendment that happened to the Employment Act that happened in 2021. I think mainly the 2021 amendment was focusing on the introduction of the flexible working hours for women or employees who are ladies or female employees, to an extent that they can have flexible working hours when they are pregnant. And also at the same time, there was an issue of introduction of the paternity leave. And for 2011, I think, as you are aware, after the introduction of the Pension Act, the Employment Act was amended to remove Section 35, or to amend Section 35 to say that the severance pay will no longer be mandatory, but it would only be payable under special circumstances, like the the retrenchment or the redundancy. So at first, the payment of the severance was mandatory. So that's what we should be able to understand. And after that, I think we should also to appreciate is to say this kind of an amendment, that's what brought in the issue of the pension into force. So when you look about the Employment Act of 2000 and the subsequent amendments, what you need to appreciate is that there was now introduction of within that, as I said already, this forms the basis for the contracts, the terms and conditions of service, besides other laws. You can have the pension, to be part of the terms and conditions of service. Pension Act could be part of the terms and conditions of service. The Occupational Safety Health could be part of the Pension Act. The labor relations could be part of the terms and conditions of service. Besides that, you could also have the Workers' Compensation, Gender Equality Act, HIV/AIDS Management Act, and the other acts of Parliament, including the Constitution and other policies. But the Employment Act, maybe it takes maybe 60% of the whole terms and conditions of service. And I think what you need to appreciate is that maybe if you are reviewing or you are developing your terms and conditions of service, I think we are available to support you, on what you should be able to include or to remove from your terms and conditions of service in light of the law, with all those laws which are just talked about. So you look at issues of, for example, the notice is covered in the Employment Act to say if you want to give a notice to your employees, how much time do you need to give each other? What's the minimum, depending on the number of months, the number of weeks that that employee will be working for you. So whether it's on probation, do you need to give a probationer a notice, or should the probationer provide a notice to you, and all that? So that kind of condition is what you should be able to have it in your terms and conditions of service, because there's something that the law says. So whatever you agree should be in line with the law. So whatever is in your contract, is your offer letter, is in your terms and conditions of service, should be in line with the law. Likewise, issues of leave, you look at different types of leave. For example, you talk about the annual leave, which is part of the law. It's in the Employment Act. You talk about the paternity leave, after the amendment of 2021 is part of the leave. The maternity leave is part of the Employment Act. But the sick leave is part of the Employment Act. But the other leave is like study leave, compassionate leave, and unpaid leave. These are not part of the law. So we should also be able to appreciate that, to say which things are part of the law and which things are part of the. So there are certain things which I think there's a session which I was discussing issues pertaining to mandatory and discretionary benefits that are applicable to employees. So the mandatory obligations and also discretionary obligations. So these are some of the things that we need also to appreciate, to say which things are statutory and which things are out of benevolence or out of goodwill. So these are some of the important things also we should also be able to appreciate. So I think when you're developing your terms and conditions, that thing should be very clear. So you look at issues of discipline, for example. How should you discipline your employees? The Employment Act provides the procedure for disciplining your employees. When should you give a warning? When should you summarily dismiss an employee? When should you suspend? Why should you suspend? But in the terms and conditions of service, you might need to provide a detailed explanation on how you want to discipline, or in the disciplinary policy, you might need to provide a detailed explanation of how you want to discipline your employees, for example. But whatever you're doing, you should be able to do it in light of the Constitution and also the Employment Act, because in the Constitution there is the right to be heard, which is very, very important. You will not just discipline an employee. Would you discipline, for example, someone who is on probation? Would you discipline, for example, someone who is his contract is coming to an end? Would you discipline someone who has resigned, for example? So these are some of the things that now you can include in your terms and conditions of service. So as I said, you can engage us as Change Mozart Group to help you with that kind of how best can we be able to develop terms and conditions of service, also employment contracts and also the offer letters which are in light of that. And also issues of leave, for example. I think I already explained that, to say what the different types of leave which are there. But also the Employment Act focuses on the duties of the employee and the duties of the employer. Once an employee has to work, so what are the responsibilities of an employee, and what after the employee has worked, what should the employer provide? That's why the employer has to provide at the end of a certain period, because it is assumed that the employer is paying for the work done. So that's why we pay at the end, why employers pay at the end of the certain period. But also there's also a limitation to say you cannot deduct an employee that is going home with nothing. There's a limit to say how much you can be able to deduct from an employee, for example, in terms of loan. So whenever you are doing your calculations, make sure that you are not going beyond a certain threshold, so that at least the employee has also something to. So the Employment Act has got that. So even when you are developing your terms and conditions for policy, or even the loan policy, you might need to include such kind of things to say what threshold can we allow for an employee to, when we have disbursed this loan to this person, his salary should not be more than, his deductions should not be more than this percentage of his salary. So though that will come from the Employment Act. Wages, yeah, so the Employment Act also recognizes for you to pay wages to your employees. Yeah, wages could be salaries and other things, yeah, and benefits what are applicable. So whatever you agree to pay, yeah, you should be able to pay to the employees at an agreed interval. So you should also be able to state. So in the terms and conditions, you might need to agree what date are you paying that salary. There's also an element of equal pay. So when you know about equal pay, it means to say you should be able to pay people who are doing a similar job, yeah, when people to pay equal salary. Well, I'm not talking about same salary, but at least equal salary. For example, you have a systems programmer and also another systems programmer. You can ensure that they are in the same band. So it means they're on the same grade. So you're paying the same salary. Regardless that maybe one can be on entry level, someone can be at an upper notch because of the ranks of service and all that. So that's what it is trying to say. Yeah, rather than someone who is earning 100% of the other person. Yeah, so that's also a big problem. So issues of child work and child labor, the Employment Act also talks about that, to say what is child labor and child work. So we can also define from the Employment Act, we can say as an organization we cannot be able to recruit an employee who is below the age, or this kind of age, for example. So that's also another important thing that we should also be able to appreciate. And apart from that, they're also providing the different kind of contracts which you can enter. We all know that an employer, whenever you have employed someone, whether you have communicated in writing or verbal, there's a contract. Yeah, a contract is either implied or in written form. So whenever you have communicated a contract to someone, you just know that there's a contract. And even there are different kinds of contracts which you might wish to appreciate, which will, I think I said this is just, I'm just giving a summary of the Employment Act. I will be able to go into details in the subsequent parts, videos, or in this YouTube. Yeah, so there are about 3 types of contracts which you should be able to look. So depending on the situation, you should be able to look at to say, what kind of contract am I entering this person? But what is key to appreciate in employment, we don't have temporary contracts, and also we don't have the temporary contracts are not there. Yeah, so internship contracts, we don't have them. Yeah, so that's what you need to appreciate. Within the law, we don't have such kind of an arrangement. Yeah, so the Employment Act doesn't have that. So you should be able to look at to say, under what contract are we engaging this kind of employees. Yeah, there's also a mention of the minimum wage. Yeah, the government it gives powers to the Minister of Labor to set minimum wages after consultations. Yeah, so you can also be able to look at to say, what's the minimum wage for your organization? So when it talks about the minimum, you can be able to provide more than that. Even the annual leave, you can be able to provide more than that. The notice, you can be able to provide more than that. The wages, you can be able to provide more than that. So what we need to appreciate is the terms and conditions say the probation, you can be able to provide more than that, because it provides the minimum that you can be able to agree. Yeah, so the minimum wage is not like whenever you have the minimum, it means every employee should be paid at the minimum. But that's the minimum. You shouldn't go beyond below that. Yeah, there's also an element of whenever probation. Yeah, how long can an employee be on probation? So within your terms and conditions of service, you can agree to say maybe senior officers would be having to give so much months as a probation. I mean, as a notice during probation, or maybe it can be so much months on probation. Junior employees can be so much months on probation, and what happens when they're on probation. So those kind of things can be in your contracts, can be in your offer letters, can be in your terms and conditions of service. So as I said, we are there to support you, your organization, in terms of how we can be able to meander how to include such kind of terms in your terms and conditions of service. The certificate of service, yeah, at the end of a period, you can be able to indicate in your terms and conditions of service that you provide terms and conditions of service. You provide the certificate of service, including even the terms and conditions of service. Yeah, on the duties of employer and employer, I think the Employment Act provides what kind of obligations the employer should provide, what kind of information. Yeah, you can be able to provide the terms and conditions of service to the employees. Yeah, so that is also very, very important. Yeah, it also, the Employment Act also talks about the transfer of contracts. Yeah, you should be able to know that whenever contracts have transferred. For example, I own a company, but maybe I've got a brother, a sister. My company is not doing fine. I'm transferring my company to my employees to another company. Well, the obligation now, is he taking over also the obligation that I had with my employees, for example? If there are some benefits, for example, which I was supposed to pay them, is he taking over the service? Will it not be affected? So those are some of the things that also have to be considered when you're developing your terms and conditions of service. Issues of overtime, yeah. There are different types of overtime, yeah. Day off overtime, yeah. Or ordinary overtime, yeah. So those are some of the things that also we should be able to appreciate. So yeah, you can have in your terms and conditions of service and be able to include that to say how do you calculate overtime within the, so we can also be able to support you. So, but you should be able to use the Employment Act whenever you want to decide what kind of overtime you can be able to provide. Yeah, separation, employees can resign, for example. Separation, employees can resign, can be dismissed, can be terminated, can die, yeah, can go missing. So how do you handle such kind of issues, for example? So the Employment Act also tend to guide. So you can also have such kind of scenarios in your terms and conditions of service. What kind of support can you provide to the employees when such kind of things have happened? They have retired, for example. Yeah, they have retired on money grounds, on the long service, or maybe after reaching the retirement age. How do you support them? Yeah, what kind of support can you provide to them? Yeah, so all that we can be able to support you to develop in terms of conditions, so that is speaking issues of pension, for example. Yeah, how do you place your employees on pension? Yeah, issues of redundancy and retrenchment, very, very important. How do you conduct retrenchment? What are the steps to be followed? Yeah, company is not doing fine in business. What's the procedure as required by the government? So we can also be able to support you accordingly. And you should have a retrenchment and redundancy procedure in your terms and conditions of service. So you can have a separate policy on retrenchment and redundancy procedure. Should the employees have to be consulted? Yeah, and all that. There's also an element of severance pay. Yeah, how do you calculate severance pay? Under what circumstances is the severance pay payable? Who is eligible for severance? So we can also be able to include that in your terms and conditions of service. Not everybody who is eligible for severance. The Employment Act has guided, and after the amendment of Section 35 in 2011 on who is eligible for severance. There is also a circular on who is eligible for severance. So we can be able to support you accordingly on who should be able to earn severance pay. So in short, what I'm trying to discuss is to say we are there to support you in terms of development of terms and conditions of service, development of the different policies related to HR, so that whatever you're doing it in light of the various laws which are there: the Employment Act, the Workers' Compensation, the Occupational Safety Health, the Gender Equality Act, the Pension Act, the HIV/AIDS Management Act, yeah, amongst other acts which are there. Yeah, so even including the supreme law, the Constitution. So we're always there to support you, yeah, as Change Concert Group, we're always ready to support you. But what is important for us to appreciate is you have to understand that the Employment Act forms maybe 60% of the terms and conditions of service, of which should form 60% of the terms and conditions of service of each and every organization. So that whatever you're doing in light of the law. Because the terms of the Employment Act guides the relationship between the employer and the employee. Thanks so much for watching. Look forward to the subsequent parts of the videos on the Employment Act. Thank you so much.